There's been a brand new landmark court case in whether or not we can copyright protect something created in part or in whole by artificial intelligence. We're talking to everybody's favorite IP and entertainment lawyer, Tony, to find out more. And we're going to talk a little bit about whether or not artificial intelligence can count as work for hire.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that is dedicated to all things intellectual property.
There is a brand new breaking case in the world of AI and granting copyright protection to AI created content. So, Tony, what has happened and what do we need to know as authors?
The short end of it is that anything that is created using artificial intelligence will not receive copyright protection. We've covered this story in our last video. You can check it out, link in the bio or link in the playlist. But this is a monumental lawsuit for many reasons, coming out of the DC District Court, first landmark case across all 50 states that gives us a sense of understanding of where copyright law stands, or where AI rather stands in the meter of copyright protection. And the bottom line is Judge Beryl Howell of the DC District Court essentially ruled that anything that lacks substantial human involvement will not receive copyright protection, and that extends even to works that are created using generative artificial intelligence. Mm-hmm. So if you were to go onto the likes of DALL-E or Midjourney or Stability and ask the platform, make me a painting of a dog eating a hamburger, the artwork that is generated, that output is not going to get copyright protection whatsoever. And this is just groundbreaking in so many ways. This is going to have a ripple effect across the board. Obviously, this lawsuit extends specifically to a dispute between the author of an AI-generated piece of artwork. His argument was that it should receive copyright protection because he basically gave the information to this AI platform and he's just trying to get the output registered. The Copyright Office said, no, this is not going to get it, lacks substantial human involvement. The Copyright Office won very much by a landslide here. The DC District Court took the position of the Copyright Office, and this is definitely going to extend to so many other aspects of industry that are trying to lean towards or heavily rely on artificial intelligence in some capacity, whether we're talking about music, maybe even film, television, which is kind of adapting into the AI norm in some capacity. But this is quite literally a ripple effect across the entertainment industry.
And I think it's really interesting because they kind of made the argument that using AI is like work for hire. That's something we hear a lot in the publishing space, comparing AI writing to ghostwriting or comparing creating a book cover through AI to outsourcing to a book cover creator. Can you speak a little bit about that?
Yeah, I do not buy that argument whatsoever. I think any good lawyer that has a bearing of how work for hire law works is going to agree with me entirely on this one. The bottom line is work for hire is such an intricate legal principle within the realm of copyright law that it basically boils down to two things, right? The first is, let's use your example of outsourcing because that's an excellent example. Let's say that I wrote a book and I can't illustrate for the life of me. So I go out and I hire someone, an illustrator, actually someone who is skilled in the art, to do it for me. But because it's my book and I want that artwork to be associated with the general copyright of my publication, I don't want the illustrator to own the copyright to it. So obviously I'll give them the credit, but I don't want them to be the sole copyright owner, because now at that point it disrupts a lot of things. Now the publisher has to get them involved, and then they got to get a royalty, and so on and so forth. So I'd rather just have a one and done work for hire situation. How do you do that? With a contract. Get a work made for hire contract. And if there are any authors out there that deal with work made for hires, please, please, please always get a contract. It's going to save you so much time, because the work made for hire contract is going to clearly lay out all the terms, including conveyance of copyright ownership, meaning that at that present moment, when the illustrator is sitting there illustrating, they're technically the copyright owner because they're illustrating in real time. But once they're done and over with, they send that over to the author, the one that eventually is going to become the copyright owner, and they, by basically getting that completion, a completed work of authorship sent over to the author, that act creates that conveyance of copyright ownership that then would allow the author to go to the Copyright Office and register that officially and be done with it and over with. The contract would lay out the terms between the author and the person that's been outsourced this task about copyright ownership and basically the responsibilities that they have under the terms of that contract. You need those types of contracts, because if you don't, then you got to go over to scenario 2, which is you have to work off of an 11-factor test, which is such a pain in the neck. And it basically boils down to looking at what tools were used, that the person that is that was outsourced this activity, did they use their own tools or did they use your tools? Were they treated as an employee? Did they get what was their tax treatment? Did they get benefits? What was the kind of like the period in which they were, I guess, being supervised? There, it is such a comprehensive 11-factor test that is all laid out in this case, Reed versus CCNV, Community for Creative Nonviolence, penultimate case on work made for hires in the realm of copyright law. It basically dealt with this sculptor that had made a modern day take on the nativity scene. And he's saying, yeah, I'm the copyright owner. And CCNV, the organization that commissioned the work, says, no, not so fast. I'm the copyright owner. So it basically turned into this Spider-Man meme where the two Spider-Man are pointing to each other. And then they went to a full-blown litigation. And an assessment of the facts showed that in some regard, Reed was actually more of the proper copyright owner because of based on the assessment of the 11 factors, the needle moved more in his favor as opposed to Community for Creative Nonviolence. So to save yourself the expense of an 11-factor assessment in a full-blown case, you're better off just having that contract. Now, I'm setting this up because that's something that AI is incapable of doing. They cannot enter into a contract or at least understand or contemplate the nature of being a work made for hire contract, being in a work made for hire relationship. When you use a platform like OpenAI, or you use Stability or Midjourneys or any other AI engine out there, you really think that the developers are going to respond to your email saying, hey, you know what, I'm going to use your platform, but we need to treat this as a work made for hire agreement? By you giving your Google account or your email and creating an account on these platforms, you are unilaterally agreeing to their terms, and their terms have no reference whatsoever to work made for hire situations. All it says is you put in you provide the input, the output is whatever product comes out based on what you gave what prompt you gave the AI engine. And then they say, generally, you are now the owner of the output. That doesn't mean that you're the copyright owner. It just means you are the owner, meaning you own the digital file. But physical ownership has never meant or has ever correlated to actual copyright ownership. Not now, not ever. So it's something that obviously is breeding ground for a disaster, a legal chaos, if we're really being frank about it. And so I think that if there are any entrepreneurs, authors, anyone else in the entertainment space that is actively trying to use AI and thinks, oh, I could just treat this as a work made for hire, legally, the foundational arguments just don't make any sense whatsoever. There's just no justification, and it's just not going to fly in a court of law at all. It's just going to fall flat on its face, and you're going to be embarrassed, and you're going to be bench slapped by the judge, with a ruling that's going to be crass and quite embarrassing because it's now going to be on the record.
And it's incredibly important to make sure that you're not getting yourself into that situation. So moving forward with this, now that we've had this case, and if you haven't watched our last episode on the main channel, we're going to link that down below for you. Very important for you to go to watch that. We talked about originality and creativity and how AI just cannot be having that conversation in order to transfer those rights over to us. If you've got questions of this, it's a great opportunity for you to drop those now because Tony's coming back as things continue to roll out. But Tony, as authors, as publishers, as people in this space, knowing now that it has to have human authorship to gain that copyright protection, and knowing that AI doesn't have the ability to do that or transfer those rights over to us, how should authors be moving forward, considering using this inside of their platforms in terms of book covers and writing their novels, editing their novels, tweaking things? What do we need to know?
If I could tattoo it on my forearm, I would. And I'm going to ride or die by this argument that I've said in previous videos. You can quote me. You can find every video that I've ever done with KM, and I've said it repeatedly over and over, and I'm going to say it for the 50th billionth time. Use AI as a tool, as a source of inspiration. Do not use it as the form of replacement for whatever work you're trying to put out. What AI presents, generally speaking, is quite impressive. It is inspiration in every sense of the word. And it's just fascinating, the acceleration that AI has had in industry today. That said, whatever idea AI could come up with is so unoriginal, because the only way AI comes up with those ideas is because of information that's been ingested into that platform. It's a learned language model at the end of the day. The only way it's going to know what to say is because it's been learned, it's learned data that its developers have ingested into these platforms day in and day out. And as they perfect the program, they keep feeding it more data. That's how this goes. It's not a search engine. It's data that is just being housed in a server and is providing all this output to everybody. It is honestly so alarming that people will think that just going on AI and making a quick buck out of it is that's how you make it in the business. That is so lazy. And I'm going to teach everybody a classic expression that my deceased Cuban grandfather taught me growing up. Rest in peace. Who was a hard worker in every sense of the word, literally lived the American dream. And he taught me a phrase that lives in my head rent free. El aragán trabaja doble, which means the lazy man works twice. And that is the correlation with AI. AI is not going to do the job that a writer that actually just sits and thinks in their mind what they're going to write up next. It's just something that AI is incapable of doing. And listen, writer's block is a real deal. Sometimes you recycle the same story and it gets a little dragged on. Whatever, it happens, right? But if you just sat down and you conceived of an outline or a game plan, or maybe even laid out like different titles and then kind of wrote out maybe different narratives based on those titles, I guarantee that you would have a much more formidable work of authorship there than anything AI could ever generate. It's going to be unoriginal if whatever AI creates, and that's the essence of what makes a copyrighted work so special. Copyright is an original work of authorship fixed in a tangible medium of expression. Originality is the most ridiculously low threshold in all of intellectual property law. It just needs to be the bare minimum of creative. So as someone who cannot illustrate for the life of me, I could draw a stick figure for days, but that stick figure is not going to get copyright protection. But the moment I draw a mustache and a top hat, courts would say, you know what, that's really original. That's going to get copyright protection. And hey, that shows you how low that threshold of originality is. That concept of originality is something that is not tangential. It is not. It is not going to be found in any AI LLM ever. It's not. It's just not going to be a thing. So generative AI should be literally treated with a grain of salt. This landmark case, this Thaler Perlmutter lawsuit or decision that just came down in the DC District Court, is a landmark case in every sense of the word. Surely is going to have longstanding effect across the entire entertainment industry. And as we have more AI cases coming up down the docket, it's going to just accrue, and it's going to give us a sense of reinforcement as to where AI stands in the copyright space. The way you could fix that problem, or if you don't want to necessarily call it a problem, but the way you address that issue is by having reform in legislation. Maybe if Congress one of these days actually passes law, they would actually be able to pass maybe an amendment to the Copyright Act that explicitly touches on AI and copyright protection. Maybe that's something that's going to happen down the line. But right now, the DC District Court has made a loud and resounding alarm sound for all 50 states. Anything that is generated using artificial intelligence will not get copyright law. Authors do not treat AI as your writer, your editor, your anything. It is not going to do the work for you. And just stick to your good old 10 digits. It's going to do the work much more efficiently and effectively than AI.
And we have had conversations on how AI learns. We've had conversations about the court cases where authors are suing AI creators because of how they're inputting their content. We have had conversations on how you can legally, ethically, and creatively be actively using AI inside of your business without getting in trouble or causing you any issues. All of that is in the playlist. We're not arguing. We're not having conversations that are disregarding what is going on from the professional here. All of it's down below. If you've got questions, we want to get those answered for you. And Tony is coming back every single week with new episodes with us. We're breaking down the court cases as they roll out. This one is brand new. We've talked about the other ones. We've talked about the significant impact humans have to have in order for it to happily, or in order for it to get that copyright protection. We've had all of these conversations, and we're going to continue to have the conversation. So as things continue to happen, follow along for more. Drop your questions for Tony down below. And if you just want to hang out with Tony because he's a really cool, awesome, knowledgeable human being who is giving us all this breaking news and keeping us legally protected in the publishing space, you can also hang out with him online. So Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor. And you can check out my entertainment law podcast called Unseen, with new episodes dropping every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
Follow along for more breaking news in the world of artificial intelligence and the publishing industry, and drop your legal side of the publishing industry questions for Tony. He's coming back for upcoming episodes. And follow along for daily videos that help you navigate your publishing journey, from your writing to your publishing to your marketing. We want to make sure that this is your most profitable year ever, so that you can live your best life while also living out your author dreams. We'll see you in the upcoming episodes.